A Texas judge approves an emergency order for a woman to get an abortion after a fatal fetal diagnosis.
This case proves that abortion is essential, life-saving health care.
But supporters of the state's abortion ban are pushing back.
It would be wrong. It would be, hubris. It would be prideful for us to assume we have the authority, ethically and legally, to take a child's life.
We look closer at the debate and how the case could have an impact on other challenges now playing out in the courts. Tensions rise in Washington over a push to limit who can apply for asylum.
I see this as a unique point of leverage to force the administration to talk to us about policy changes that will change what's happening at the border for the better.
How a key Texan is making the case for major changes on the border.
I remember as a child very vividly him telling me, "Estudia, mija, study, so that you don't have to work in the fields like I do."
From humble beginnings to a key position in the courtroom, how a Texas judge earned bipartisan support to earn a spot on a federal court.
Produced from the Capitol in Austin and airing statewide, this is the award-winning State of Texas.
Hello, and thank you for joining us. I'm Josh Hinkle. A district court judge approved an emergency request Thursday from a Dallas woman seeking an abortion. Then on Friday, the state made its own emergency appeal, asking the Texas Supreme Court to block the order. The back and forth battle focused on one woman's case, but as Ryan Chandler shows us, it could affect a larger challenge to the state's abortion law playing out in the state's highest court.
Kate Cox, pregnant with her third baby, never imagined seeking an abortion in her journey to build a big family.
Every day of this ordeal has been agonizing for her.
Cox's daughter was diagnosed with full trisomy 18, a fatal fetal abnormality. It could also put Cox at risk and prevent her from having any future children.
This case proves that abortion is essential, life-saving health care.
A Travis County judge agreed, but Attorney General Ken Paxton alerted Cox's hospital and doctor they could face prison time regardless of that ruling, writing, "The order will not insulate you from civil and criminal liability, including first-degree felony prosecutions." Then on Friday, Paxton appealed to the Texas Supreme Court to block the order altogether. Supporters of the ban argue the birth should occur regardless of the diagnosis.
It would be wrong. It would be, hubris. It would be prideful for us to assume we have the authority, ethically and legally, to take a child's life because we are not sure about a disability.
The order applies only to Miss Cox's current pregnancy. Her lawyers hope this precedent will lead to other favorable judgments in other challenges. They're awaiting judgment in a separate challenge, led by 20 women, many of whom faced similar medical emergencies, but say the law prevented their doctors from acting until they nearly died. That case is now up to the Texas Supreme Court. We asked the Chief Justice about that. He hopes Texans trust that the court respects the rule of law.
It's not a political decision for them. It's a legal decision. And they have to decide cases all the time that are difficult. We just want it to be, we want to not ever do anything that makes it look like somebody didn't get a fair shake.
Ryan Chandler, State of Texas.
We want to take a deeper dive into the case and the larger ramifications. Ryan Chandler joins us now. Hi, Ryan. Thanks for joining us.
Thanks for having me.
So what are the major differences between Cox's case and the one in front of the Texas Supreme Court?
Well, so this is important. The critical difference in the Cox case is Ms. Cox is pregnant now. She argues that this is an emergency and she needs an abortion in the future. In the other case called Zarowski v. Texas, these women are arguing that they previously were harmed because their doctors could not perform an abortion when they were in an emergency. Now, the state is arguing those are different because in Zarowski, their harm, if you will, had already passed. So they say that they no longer have standing to sue because they are not pregnant, therefore the abortion law does not apply to them. And many of them do not plan to or cannot get pregnant in the future. So they say, well, they're just not the proper plaintiffs to bring this case. The Cox issue is different because she was pregnant and faced an imminent future harm.
Now, you spoke to the Chief Justice about that case this week. What did he have to say?
So he couldn't really share where his mind is on the merits of this because, of course, it's a pending case. We're still awaiting their ruling on this. But he did stress that he's very concerned about the politicization of the court. The idea that there are Republican and Democratic judges and pro-abortion and anti-abortion judges. And he says that we really need to shy away from the politics in the judiciary. It is a little different in Texas because there are Republican and Democratic judges. That's how we elect them. But he doesn't want politics to determine how judges rule in these. And he says no matter how the court comes down in the Zurawski case, he says he wants the public to believe that the Supreme Court acted according to the rule of law and objectivity, not politics.
For other women who may be in similar circumstances, what recourse do they have?
Well, so in the Cox case, that applied only to Ms. Cox and her current pregnancy. It's not a general ruling that could apply to any other woman. So if there's another woman out there right now who also received that tragic diagnosis of trisomy 18 like Ms. Cox did, she would also have to go to a judge and get special permission just like Cox did. It's on an individual basis now. Now, Cox's attorneys are hoping that her precedent could lead to a case that more generalizes rulings like that, like the Zurawski case, of course, because they argue that, you know, if a woman is in an emergency like this, going to a judge and asking for permission to get that care is the last thing on their mind.
All right, Ryan, thank you very much. For perspective, Texas voters have mixed views when it comes to whether the state should expand legal access to abortion. A poll from the Texas Politics Project at the University of Texas found 49% believed that the state should increase abortion access, 34% disapproved. Democrats and independents in the poll were more likely to support increased abortion access, while more than half of Republican voters were opposed. The fourth special session is over. Lawmakers left the Capitol without passing the governor's priority plan for education savings accounts. Funding for school safety measures also failed to pass. At a news conference Tuesday, Lieutenant Governor Dan Patrick put the blame on House Speaker Dade Phelan for failing to push bills through in the final week of the special session.
He had 6 days to go. A session is 30 days. That's 20% of the session. What the hell was he doing for 6 days? He could have called him back on Saturday, called him back on Sunday. He could have done something Friday. He could have called him back Monday. They had time to act today.
Speaker Phelan released a statement touting priority legislation that did get accomplished during the year. A spokesperson for Governor Abbott released a statement saying the fight for school choice will continue until it's won. But the governor has not said if or when he plans to call a fifth special session. State officials say they've stopped a series of lawsuits that threaten to delay property tax cuts and other constitutional amendments approved by Texas voters last month. Conservative activists filed lawsuits challenging the election results. They claim voting equipment was not certified and the machines were connected to the internet. The state says the lawsuits are not valid, in part because they were filed after the governor canvassed the results. A spokesman for the governor's office tells us the 13 amendments approved by voters are now part of the Texas Constitution. The Department of Public Safety is fighting to stop the release of records and video of the response to the Uvalde school shooting. Families, the media, and lawmakers have sought answers after learning law enforcement waited more than an hour to confront the gunman. Last month, the Travis County judge sided with news organizations in their lawsuit for access to DPS records of that day. But on Friday, DPS filed an appeal, blocking the release of those records, at least temporarily. DPS has claimed before that releasing records could interfere with ongoing investigations into the shooting and the response. The state Republican Party under fire after rejecting the idea of banning association with known Nazi sympathizers, the condemnation coming from the Capitol. Tensions rise in Washington over a push to limit who can apply for asylum, how a key Texan is making the case for major changes on the border. And from picking cotton to a presiding position in the courtroom, meet a Texas judge making history on the federal bench.